Imagine that two newly licensed attorneys are given the same project with the same deadline, 3 hours from now. Let's call them Sarah Strategy and Willy Nilly. This could be you soon. This is Sarah Strategy. She has a research plan and efficiently researches. This, on the other hand, is Willy Nilly. Easy as it may seem, you don't want to research like Willy. Here's the trouble. There's a lot of research to suggest that the internet is making us shallow thinkers and cursory readers. If you approach legal research like you approach a Google search, you very well may end up with a wrong or incomplete answer. This video series will introduce you to a simple research strategy to act as your compass as you navigate the sometimes murky waters of legal research. Armed with this compass, you will be a confident and efficient researcher. We hate to pick on poor Willy Nilly, but let's use him as an example. Willy's boss asked him to research a defense to a federal copyright claim. The client, who had produced a song, wanted to argue that his song was a parody protected under federal copyright law. The problem is set within the Sixth Circuit. Instead of using an efficient legal research process, Willy tried to repurpose what he knows about research on the internet and apply it to the legal question before him. Where do you think he started? Let's take a look. As you watch Willy, make a list of ways he can improve his research.
I can do this. I can write a memo. Okay, I need some law. I'm going to go to Google. Oh, parody. There it is. Let's see. Teach me about parodying. Modernist, film stuff, Canada. I need some law. Where's the law? Copyright issues. Sweet. Statute. Okay. Subject to further revision. So this may or may not be the current law. Well, something's better than nothing. I'll copy that, throw that in the memo, and I am off to a great start. But I need more law. What else do we have here? Oh, form. Somebody else has dealt with this before. Let's see. No sense for nonsense. Help me out. Looks like it's a bad idea. Somebody said, little hearsay, looks like. That's right. Somebody's opinion there. They know more than I do. Oh, Stanford. I can trust that. I wonder when this was written. I'll do a search for parody. Okay, that's a book. Close enough. Looks like an important case. Catcher in the Rye. That's an important book. So I'll add that to my memo. I need something else. Oh, here's an example. Weird Al Yankovic asked Lady Gaga. I was born this way. I perform this way. That's great. Looks like he asked for permission, so maybe you need permission before you parody. So I'll throw that into the memo, but I need more law. So I'll go to Westlaw for that. What's all this right here? Oh, there's a Google-looking bar. I'll use that. What do we get? Oh, that Campbell. I've seen that before. There's a yellow flag. Oh, statute. I have that statute. I need cases. I don't like that yellow flag. Let's see. Oh, there's one without a yellow flag. It's about a song. Okay, good. I'll add that. What else do we have? Leibowitz. I'll add that. That looks good. What about Campbell? It's from the Supreme Court. I might as well use it. That's good enough. 3-4 cases. We'll see what happens.
Willy gives the research to his boss. Right away, his boss could tell that Willy had missed critical law. So what went wrong? Well, lots of things. First, Willy wasted time by failing to follow a reasoned research strategy. Second, Willy equated research with run a search. But experienced lawyers know there's more to it. Research involves analysis and critical thinking, not just search terms and hit lists. Third, Willy couldn't verify that his statute was still good law. Fourth, Willy didn't verify the source of his law. For example, if we search online and find a tempting recipe and we have all the ingredients, we usually don't care who wrote the recipe. Legal research is different. The source of the information is critical because it determines the authority's weight and place in the hierarchy of legal authority. Fifth, Willy got trapped in the top 10 list mentality. Earlier in my example, it didn't matter that there were 16 other good recipes farther down the list. If I found a good one at number 2, all was well. Not so with legal research. The case most applicable to your client's facts may be down the list at number 84. Lastly, Willie overreacted to the cautionary signals. Think of them as a heads up, and that's it. You can't afford to research like Willie. You want to be like Sarah, at least as far as her approach to legal research goes. Let's pretend Sarah gets the same assignment Willie received. She's at a deposition, but she sees the partner's email during her lunch break. Right from her iPhone, Sarah does the same thing Willie does. She Googles copyright song parody. She also sees hit number 2. She makes a few notes on her iPad, the statutory citation and the search term fair use. She reads the article to start educating herself a bit about the law. When she gets back to the office, Sarah is ready to dive into the research. She naturally turns to a 4-part research strategy. Part 1, preliminary analysis. Part 2, check for codified law. Part 3, check for binding precedent. And Part 4, check for persuasive precedent. Sarah knows that the Google search results fall squarely within preliminary analysis, where the reader gains context by reading secondary sources. Because Sarah isn't an expert in copyright law, she needs more than the Google results. Like Willie, Sarah consults Westlaw next, but instead of running a search, Sarah goes there to find expert commentary. Let's take a look at how she did it.
Okay, part 1, preliminary analysis. For this, I really need a treatise. That's going to give me expert commentary that will help make me feel grounded as I approach this unfamiliar area of law. On Westlaw Next, I'm going to go in by topic. That's really the quickest way to find an area of law treatise here. And I have one on copyright law that's perfect. That should be really helpful. Lots of information here, and there's a whole chapter devoted to that fair use defense, which seems to be where my parody claim will fall. So I can read up on the statute. I see here that there's a 4-factor analysis as the framework for evaluating these fair use cases. So I'm going to really focus on that. And it looks like of the factors, the first one really captures the parody argument. So I'll read through everything, but I'm going to focus my attention on the first factor. It does look like the Supreme Court has spoken on this topic in Campbell. I will definitely take down that citation, as well as some of these other citations. These will provide a good starting point for me for my research.
Now that Sarah has background information, she's ready to search for codified law. She starts with the statutory citation she found on Wikipedia and in the copyright treatise.
After spending some time with the treatise, I'm ready to move on to codified law. That's part 2 of the process. Now I have that statute, 17 U.S.C. 107, that definitely seems to be the on-point statute, so I'm going to pull it up and verify. I'm first going to verify that this is the statute in force as shown on Westlaw, and then I'm going to take a step back and get some context. I need to see where this statutory section fits within the larger organization of the Federal Copyright Act, and I need to make sure that there aren't other sections of the statute that I need to be looking at. Also in this step, I can use the annotations of the statute to guide me to other on-point cases to put with the ones I've already found.
With the background information and the statute in hand, Sarah is ready to search for binding precedent, that is, cases from the applicable jurisdiction, in this case, the 6th Federal Circuit.
During step 3, I need to assure that I have all of the binding cases from my controlling jurisdiction. I turned up lots of promising cases during the earlier steps, but now's the time to be comprehensive, using the West key number system to search for cases by category. Searching for fair use, Westlaw directs me to 53.2 under copyrights and intellectual property. That's the right topic for me. In fact, I ran into it in my secondary source earlier in my research. I will ask Westlaw to direct me to the cases from my jurisdiction that have a headnote that falls within that category. The list I get is rather long, but I will need to be comprehensive and go through this, at least in a preliminary way, to take a look at everything. But first I'll zero in on those cases that are most relevant by adding parody or song to the search criteria. On my shorter list, I have that Campbell case again, as well as some other Sixth Circuit law. I'll start here and then expand my research.
In Part 4, the researcher would go beyond the controlling jurisdiction to search for persuasive precedent. Because Sarah found the answer in her own jurisdiction, she didn't automatically march on to Part 4, the search for persuasive authority. She was confident that her research was complete. She emailed her analysis to her boss. Later, she was promoted to partner with a corner office. So we hope that the point was made. Because she internalized an effective research strategy, Sarah didn't get lost in the data smog like willy-nilly did. She was able to confidently navigate potentially overwhelming legal information with a variety of media. Now that we have your attention, we hope you'll go right to the next lesson where you will learn the specifics about how to confidently tackle each part of the strategy.